Yes.
My Lord, the Commission. There are some active processes going on in Europe, and there is a press release at the end of Bundle 3, the very last tab there, to do with that process.
Tab 36.
Tab 36, yes. The European Commission has in effect been considering a complaint concerning the provisions of the Public Participation Directive. It issued a reasoned opinion on the 18th of March 2010. The government is currently considering that reasoned opinion, and pursuant to long-standing precedent, we don't, and neither do the Commission, release either the reasoned opinions or the government's response. Those matters happen confidentially. But there is that process going on in Europe that you should be aware of.
Yes.
The maximum information that's in the public domain is contained in that press release, which is why I've given you the reference.
And fairly tight time limits, are there, in response times? And so on,
I don't think we're under any immediately pressing obligation on that front. I think the dialogue continues for as long as is necessary. My Lord, separately from that, separately from the Commission's considerations and from Aarhus and everything else, the government has in any event for some time been intent on codifying the law on protective costs orders. And the decision has now been reached, or the decision has already been reached, that the time is right for that now. And as a result, the Civil Procedure Rules Committee has been asked to consider rules to codify the current position on PCOs for environmental judicial review proceedings.
specifically in that area?
Yes, specifically in that area for the moment.
But you said JR generally and environmental.
Just on JR and environmental cases for the moment.
Yes.
And I'll come back rather more broadly to JR in a second.
Right.
But the broad intention of that invitation to the Rules Committee is to seek to ensure or to encourage that applications are made early in the proceedings to be considered alongside permission issues. And there is an intention that there should be some limit, at least, on the claimant's liability for costs of the PCO application itself, which has been identified as a particular species of problem, I think particularly by Lord Justice Sullivan. Those rule changes are currently expected to come into force in April 2011.
So have the rules been made?
I don't think that they have yet been made, but the intention is to bring them in once made by that date.
Because I spent many a happy Friday chairing that committee, and I know that there is usually quite a long lead time from the making of the rule until it comes into force.
I'm afraid I don't have more details on how far that process has got, but the intention, as I say, is April 2011 for that sort of codification process, which, as you saw, at least at the heart of the Aarhus Committee's concern. Alongside that set of deliberations, Lord Justice Jackson's final report of his review of civil litigation costs more generally was published on the 14th of January 2010. The relevant extracts of that, so far as JR are concerned, are at Bundle 3, Tab 35, and we looked at them. That section considers the costs of judicial review proceedings generally, rather more broadly than the subspecies I identified earlier on, but obviously included environmental claims. And you've seen the recommendations that he makes in relation to that. Alongside that, there is the Working Group on Access to Environmental Justice, chaired by Lord Justice Sullivan, and you've seen the update report on that September 2000 or August 2010, tab 34, effectively supporting Lord Justice Jackson's findings, but suggesting a stricter test in the manner that I indicated earlier on. And I'm instructed that the intention of it hasn't yet been launched, is to consult on those broader issues very shortly. A consultation hasn't yet been launched, and it may be that it's going to be in 2 parts or 3 parts, but I think decisions have yet to be made about precisely how that consultation process is to be taken forward. But the intention is to consult very shortly in relation to that broader range of issues. My Lords, that's the position so far as Europe is concerned. Can I then turn to the objective-subjective divide and the Ghana case, briefly? Ghana itself is in bundle 2 of the authorities at tab 17. And again, you'll wish to, I know, given the interest which the court has expressed in this part of the case, I know you'll wish to consider with some care the judgment on this issue. The relevant section of the judgment starts at paragraph 41, using the bottom page numbers at page 527. And you'll see that in effect it ends just about the letter, just about at the end of paragraph 52. That section of the analysis. So that is a pair of 2.5 pages that you'll need to consider with some care. What I was proposing to do was to, as it were, invite you to read that, to take it as read, and in the time available to make some short submissions about that position and the issues that are raised.
Well, much of this was reproduced. Was it in your written submissions?
Yes, I think we quoted certain
so I think
segments
we
of it.
all had a chance of reading this.
Yes, well, I'm very grateful. Yeah. Can I then make some submissions?
Please. Yes.
You will appreciate that the position that we take on the point of principle, if it arises, and I'm going to come back to does it arise, but the position of principle, if it does arise, is that the approach of the House in the ruling of March 2007 was the correct approach, and that the test is, or at the very least can compliantly be, a subjective one, to use that shorthand, for a number of reasons. Firstly, if I can call it this, the millionaire versus pauper point. In other words, the subjective test allows you to differentiate between a claimant who has millions in the bank and the claimant who has none in the bank. And it leads to pretty odd results if you set an objective standard across the board for claimants that says the objective level of costs that most people might find prohibitive is X. If it's £20,000, that's going to impact very differently on the pauper as compared to the millionaire. That's the short point.
Especially, I suppose, when the millionaire could pay $1 million to his own lawyers.
My lord, quite so. The millionaire is a millionaire for all purposes, paying his own lawyers and paying someone else.
You can pay a fortune to your own lawyers, but the other side has to litigate at its own expense, effectively.
Quite.
And that's one hand behind the back.
Perhaps I'm jumping ahead too fast, but isn't part of the point behind the principle of not being prohibitive expensive that any person can come along and take an environmental point? It's not left to millionaires to do that.
My lord, of course, any person can bring a claim. The question is whether or not every person should be allowed to litigate at someone else's risk, which is the point I think that Lord Mance was putting to it. And if you have a system which draws, as it were, identifies a notional reasonably rich person, perhaps reasonably poor person, you end up with the cost risk being, it might be thought, rather unfairly borne, because the millionaire can litigate at the risk of only 10 or 15 or 20,000 pounds, whatever your notional middle rank is, and the pauper can't do it at all. Now, the pauper might not be able to do it But if the pauper can't do it, then the PCO application is there to allow him to bring it subject to a suitable cost cap, which might be zero. So the fact that the pauper might exist and might need access to court isn't a powerful argument, for reasons I'll come to, but isn't a powerful argument in favour of the need for an objective test. All that subjectivity does is to allow one to regulate, as it were, how much cost risk should be borne in pursuing unsuccessful challenges.
You say the point is that clear in your favour?
My Lord, we do say that, but we recognise, I hope realistically, that Lord Justice Sullivan has said that it's an important issue of principle. I'm going to come on and make some submissions about whether or not this point does truly arise in this case. But we say it is clear that the prohibitively expensive principle can be properly met by an exclusively subjective approach. It could also be met by an objective approach, and there may well be different approaches across member states as far as that is concerned, but we say it can clearly properly be met by the subjective approach.
I suspect it's going to be difficult to maintain the view that it means different things according to how countries decide. I would have thought this is going to have an autonomous meaning.
Well, my Lord, I'm not sure that's necessarily inconsistent with it being possible to set up a system which is not prohibitively expensive. Take two systems.
Yes.
The ultimate aim is not prohibitively expensive as a system. One system does an objective approach, or applies an objective, the other one does a subject. My Lord has the point. I mean, you can achieve the same outcome and apply the same meaning to prohibitively expensive by using, as it were, back from that, a subjective test or an objective test. But the first point...
Going back to your millionaire, it doesn't have to be a millionaire, I suppose. Let us suppose a large action group of small people.
Of course. Of course. And my Lord, that brings us back to the fact of this case. You will see, I didn't specifically take you to it, but if you go to the submissions that were exchanged before the March 2007 ruling, one of the live issues in relation to means was not just in relation to this appellant, but in relation to the group of people she represented. And there was an argument, I think it was called Rugby and Plume, where it certainly had a name for the group, and there was a question mark about whether or not she was receiving funding. So my Lord is entirely right. But I use millionaire versus pauper shorthand. I hope it's clear that...
I mean, one aspect of all this is that generally in these cases, actually, they find somebody who qualifies for legal aid.
They do, and they did in this case.
As they did in this case, and there are many others. But, I mean, that's why one reason I ask, what the limits of legal aid are. But I mean, the other thing is, if you are legal aid, well, then the respondent's going to get nothing.
Well, the respondent will get nothing, but that's just...
I know. I mean, it's all...
That, I'm afraid, is the way that the legal aid system works. Football pools or nothing. Anyway, millionaire versus pauper is the first point, and it seems, at least, that Lord Justice Sullivan was at least pretty alive to that point, because there is reference in paragraph 25 of the judgment to the owner of a well-known department store or certain footballers.
Is it 25?
I thought it was 25. Is it 25?
Yes, there is, yes.
I don't know whether he had any particular
Yes.
department store in mind, but anyway, the point is effectively live before him. So that's the first issue. Secondly, in relation to subjectivity, it is, we respectfully submit, appropriate for the court, in considering the benefits of one system over the other, if we're looking at that issue in principle, for the court to be mindful of the point I've now made on a couple of occasions, and which I think was a point that Lord Justice Tyson may have made in an earlier case that we've cited in one of our arguments, but which is that it is appropriate to be mindful of the fact that a claimant's boon, if I can put it that way, is funded by the taxpayer's loss. What you're doing, effectively, is to restrict recovery by the taxpayer. And in that situation, it is appropriate, in my submission, to be mindful of not setting up a system which is not particularly differentiating. Third point. There is, we submit, no chilling effect of any appreciable kind and here we do respectfully part company with the reasoning of Lord Justice Sullivan, paragraph 46. We respectfully submit that there isn't a chilling effect of any significant kind in operating a claimant-focused stroke subjective approach. It wouldn't frustrate the purpose of the article or create a chilling effect. All that the claimant-focused or subjective approach does is simply to acknowledge that some claimants may be able, without being prohibited in any way, to pay the reasonable costs of the other side if they lose. And it is difficult indeed, we respectfully submit, to see why that should put people off more generally or have a chilling effect. If they would be prohibited or would have reasonable grounds for saying on the basis of their own means, well, we're the only people who can do this and we are going to be actively prohibited because why should we take that risk, it's all too dangerous, then the court has the power to deal with that. What we're arguing about is whether the court should be able to take into account their specific and individual situation. And with respect to Lord Justice Sullivan at paragraph 50, the fact that, as he put it, many members of the public would be deterred by costs at a particular level in another case is neither here nor there. It's neither here nor there if the particular individual claimant concerned in the case before the court would not be. Whether because he has a larger or he or she has a larger appetite for risk or because they have greater means. The objective test renders it irrelevant to focus upon the individual means of the particular claimant. So that's the third point. The fourth point is that we submit that nor is it a good justification in principle for an objective element to say that there would be chilling because of examination of means in public. Now, we all recognise, of course, that the overriding principle is and should be one of open justice. And we don't see that as a disadvantage. We submit that isn't a disadvantage in terms of this argument. It is entirely appropriate and right that if someone as a claimant is going to turn up and seek to impose, as it were, an additional potential burden on other taxpayers, there should be they should be prepared to open up some minor interference, if that's the right way of putting it, with their rights to privacy. They choose to bring a claim and seek the court's indulgence by saying, please take some of the burden of risk off us. It is entirely right and appropriate that the public should understand whether that person is the millionaire or the pauper, or somewhere in between. Why is it that the taxpayer is being required to fund in this particular case? Why should the taxpayer bear that additional burden? That is a feature which we respectfully submit does justify a degree of opening up of people's resources. But in any event, even if the court were to conclude that in a particular special case there were good reasons for not doing that, because there were particular issues of privacy that arose or there were particular difficulties in the individual case, not as a general rule but as the individual case, the power is to hand. CPR 39.2 brackets 3 brackets C. We've got it to hand if you need it, but it's 39.2 brackets 3 brackets C, and it provides that a hearing may be in private if, quote, it involves confidential information, brackets, including information relating to personal financial matters, and publicity would damage that confidentiality. And there is in any event a similar sort of provision in subparagraph G about necessity in the interest of justice. So the power is to hand, if appropriate, in a particular case. So this point is not either insurmountable or, on analysis we respectfully submit, any real justification for a chilling conclusion, a chilling effect argument. Fifth point I think I got to. The objective approach or an objective element is likely, we respectfully submit, to be extraordinarily difficult to apply in practice. We've made a series of points about that in our responsive document. I'm not going to go over them. There was a decision of Mr. Justice Wynne Williams that we referred to in there, which I don't need to go to, but it provides an illustration. It is in principle going to be extraordinarily difficult to do that. How is it to work? How is the reasonable person, the reasonably rich or the reasonably poor person to be identified in terms of financial levels? Where do you set it? How do you go about operating it? Is it subject to any exceptions? It's extraordinarily difficult to see how that sort of approach should apply. We recognise, and this is perhaps the final point on the point of principle, we recognise that the different language versions that my Lord Mance referred to earlier on, in some cases refer to prohibitive in the English language, but the word excessive is sometimes used. In my submission, that doesn't provide a conclusive or any real answer to the points of principle that I've just identified. We would respectfully submit that the concept of excessive and the concept of prohibitive in this sort of context really mean the same thing. Excessive as a concept imports necessarily in this sort of sphere notions of it being excessive for the individual.
You have to compare it with something.
Yes,
excessive for what purpose?
Absolutely. It prompts the for whom question. So we respectfully submit that that difference of language doesn't lead or support either objectivity, well, it certainly doesn't lead to or support objectivity. On the contrary, we say that prohibitive is an accurate transposition of excessive, as it were, and does bring with it the notion of costs being prohibitive, and that does fundamentally focus on the nature and position of the individual claimant.
Paragraph 46, it turns its face against the purely subjective approach, as I read it.
It does.
Is that right?
It does. I mean, there's something of a dance between the two in the judgment as a whole.
Yes.
I think in fairness, the reasoning can be summarised as being, as my Lord rightly puts it, setting the face against a wholly subjective approach, but not. That's one, but two, not being prepared to go the whole way and say it's purely objective. So something of a hybrid approach.
Yes.
Does the Aarhus Convention only have one official language? We've got it in English.
Not sure. Can we check?
I mean, it uses the words prohibitively expensive, but we've got a translation of the directive, haven't we, which uses other words in...
Yes, it
German,
does. So it's
Italian
hopefully
and
provided by Mr. Wolf. We'll find out about that. We'll find out. So, my lords, that's what we say about. Those are the submissions I made.
Yes, I mean, I think it's very important to know whether we are talking about prohibitively or excessively, because if prohibitively, it does imply that you are indeed prohibiting somebody. Excessive, you can be, it's not a question, you put it just now as excessive for whom, but actually it's just excessive, and it could be excessive for a millionaire. However much he can afford it, nonetheless it's excessive because it's more than he ought to be paying to raise the challenge.
My lord, the reality is that effectively both words are being used, and one's got to try and make the sense that one can of the fact that both words have been used. In my submission, what that's, if it is double use, what that double use tends to indicate is that the concept of excessive, which in other contexts might be understood as being, as my lord indicates, is in fact being used in this particular context in the same way as prohibitive, so as to throw the focus on the individual concerned, as opposed to allowing, as it were, some notional court-imposed, perhaps, standard on or level at which costs cease to be reasonable and become excessively or prohibitively expensive. There is just something very odd about that whole exercise. I mean, just standing back and saying, well, where are we going to do it? The decision maker sits in the room and says, well, at what level are we going to put this? And how, if we pitch it at one particular level, is it going to be fair to require the taxpayer to bear the additional burden above that? And so on. I mean, how... just becomes very, very difficult to know for the people below it. What happens to the people below it? Is it to be assumed that under that level it's not problematic? In my submission, all that you do by saying focus on the subjective position of the individual claimant, which is what this debate is truly about, all you do is to allow the court to say, well, the ability of this individual to bring proceedings of this kind challenging this sort of environmental decision is affected by their means. It's difficult to see how there's anything unfair or unjust or chilling about that.
Mm-hmm. Just looking also at paragraph 46 at the end, he's picking up the point that if you look at the whole of the text of Article 15A, it does begin by referring to members of the public concerned. And one could have an environmental intrusion where a whole lot of people are affected, and the idea is that anybody, millionaires or paupers within the affected area, should be able to take proceedings in relation to that. So I think the thrust of his reference is to suggest that that points towards the objective approach.
My Lord, yes, and we would respectfully not agree with that, because all you're doing, in the example that my Lord puts to me, everyone must have access. Let's assume that's a starting point. The question is then, how is that to be achieved? Is it inconsistent with that? Is it difficult, so far as that is concerned, to apply a subjective approach? In other words, to apply an approach that says we focus on the ability of the individual claimant. If the position is that the individual claimant, the only person who's going to come forward to make the challenge, is indeed a pauper and couldn't otherwise be enabled to make that challenge, then that is a matter which the court not merely is entitled to, but absolutely undoubtedly would regard as a thoroughly relevant factor. And they would impose, no doubt, in that situation, a PCO probably at zero.
So you would say, let's wait to see who turns up, you would say, and test it by the individual who turns up, which would be fine if there's a predictable system in place at the outset, which we rather lack at the moment, but which is being worked towards.
Of course. I mean, I think one's got to, for the purpose of this point of principle, one has to assume that in all other respects, as it were, the system is compliant and sufficiently certain. Because then you isolate the point of principle and contest it. Do you need, in addition to something certain? Supposing the PCO regime was codified and did now say not prohibitively expensive and so on, and all the codification and certainty that was required by way of a codification and a redrafting of the rules. Supposing it did say that, the question would still remain, would it be impermissible in principle for a subjective test to be applied? And my submission would be no, because in the situation of the pauper, it goes to zero, they carry on. On the other hand, if the owner of the department store does turn up and you set an objective level at £5,000, everywhere above that, the state is bearing it, the taxpayer is bearing it.
So are you really saying that one should be careful not to approach this problem for what the words mean in the abstract, as it were, that one ought to assume that there is some sort of predictable system in place, and then you fit these words into the system?
Yes, because that's the only way in which one isolates the point of principle that we're considering. I mean, one can't answer the point of principle by focusing on other perceived inadequacies of the system. Otherwise, you simply muddy the waters. The question here is there only, which is why I answered my Lord Sir John Dyson's question as I did, is there only one way in which one can meet the prohibitively expensive principle in this respect? Must there be an objective standard or an objective element, as opposed to having a system which, in all other respects perfect, requires the focus to be put on the individual's means, the particular claimant's means? And my submission is that that plainly is an appropriate and acceptable mechanism for complying with that prohibitively expensive principle.
But that would mean, wouldn't it, that you could never have a costs order applying the Aarhus Convention to vary the ordinary principles governing standard assessment of costs at the end of the proceedings, because by definition the particular person would have pursued the proceedings to their end and had access to justice without a protective order. So that, in a sense, rather curiously, the extent of the protection would diminish the greater the conviction of the person pursuing the proceedings that this was an important issue and a worthwhile claim.
Well, it wouldn't necessarily follow, would it? I mean, I don't shrink from the proposition that the the appropriate and right time to raise these issues in fairness to everyone, including the prospective defendant, is at the outset and pursuant to the PCO regime. That is, after all, why it is there. No one, I think, quibbles with the proposition that you've got to, it is right and appropriate in principle for these points to be taken at that stage. The question then becomes, are there any circumstances in which it could be opened up later? One can envisage certain situations in which it might potentially continue to be live going forward, at least up to the end of the proceedings.
How?
Well, if, for example,
by definition, the person would have not been deterred. He wouldn't have been prohibited. She wouldn't have been prohibited.
Well, their means...
If it's subjective...
supposing their means had changed, supposing there had been a catastrophic change in their state of finances.
I mean, I just wonder, supposing you have two people who are in the same position, does the question whether they get a protective costs order and really depend upon their conviction that this is an important case?
My Lord, my submission to that would be, yes, you do have to have a look at whether or not they would in fact be prohibited. You do have to take into account in the situation where you have two people with identical finances, whether one has the greater appetite for risk than the other. That is a legitimate process, because what this is designed to do, after all, is not to provide, as it were, a panacea for all costs ills. It's designed to ensure that people can bring these claims to court. And if one person is less deterred than another, as a matter of personality, that is a relevant factor. And the alternative is to go back and say, we have to design the reasonable man. We have to go back and find an objective level with all the difficulties I've identified. I'm not going to go back over those. Grateful. We don't have the Russian text, I'm told. Aarhus is English, Russian and French. Authentic text.
English, Russian and French.
English, Russian.
We might look at the
wonders of modern technology. I'm sure I'm not allowed to be using that. Anyway, we've got onto the internet, and the three, I'm not telling you what the source of this information is, but the English, Russian and French are the three authentic languages. Russian we don't have. The French uses the word prohibitif.
What's the qualifying word? Dépense?
I won't be able to read that. Someone else.
That's very clever. It's probably the same.
Can we provide, perhaps you want maybe for us to provide hard copies for...
You might even give us the Russian word, and we may have resources to enable us to translate that too.
Yes.
Do you not think?
Yes.
Mr. Eadie, it's half past, just after half.
No, it is. I've got one other topic. I'm sorry I've taken a
Not
bit
at all.
longer.
We're asking
Those are the submissions on objective justice.
Thank you very much.
The question that then arises is one we've touched on already, so I can take relatively quickly, which is whether or not the issue actually arises for disposition in this reference. And on one view, my submission, the issue only arises if it is concluded that the costs officers do have jurisdiction to apply broad reductions to what would otherwise be reasonable items of cost, and thus do have to grapple with the meaning of the precise meaning of prohibitively expensive. I suppose it could also arise if my lords were perhaps convinced that...
Yes, that we can go back and look at the order.
Absolutely. So there are the two situations, but on the costs officer's side, if I can put it that way, it's important perhaps to analyse how it arises. On the costs officer's side, I've made my submissions. It isn't appropriate, is the effective and short submission, to expand that jurisdiction beyond its proper limits for the purpose of this.
Now, do you mind me asking you, going back to the other alternative, going back to the House's order, are we dealing with issue estoppel? Because it's the same party wanting to raise the point again in the same proceedings, or are we dealing with res judicata? I would have thought it's more naturally to be the former, really. And I'm speaking purely for myself, but if it would be easier if we're dealing with issue estoppel to find a way through the problems, if there be any, of the House's order having been pronounced without a full appreciation of the significance of the subjective-objective point.
My Lord, yes, I suspect that there may not be, in this respect, there may not be that much difference between issue estoppel and res judicata, because I understand that the res judicata principle is in any event conditioned by a rider, as it were, that says so long as it isn't an abuse.
I see, yes.
And so I'm not sure that there is, at the moment I'm not making a positive submission that there is
Sorry, so long as what isn't an abuse?
the raising of the point that is said to have been decided first.
Sorry, res judicata means it is an abuse to re-raise the point. So it can't be qualified by saying so long as it isn't.
Well,
Res judicata is an absolute bar. Abuse of process is something different.
Yes.
The Scottish approach certainly is as an absolute bar, but I'm not quite sure how England...
well, my lord, perhaps we better look at that again. The research that we did at least over the short adjournment on this specific point suggested that before you got to the point of deciding that it was res judicata, it was legitimate to consider whether or not the re-raising of the issue would be abusive.
But isn't that more the one party's failure to raise an issue when that party could have raised it earlier, which is not, I think, certainly not classic res judicata, and then I think the court has to ask whether it would be an abuse or not to do that.
Well, I'm sure you're right on that.
Well, I don't take that, but I think that may be an answer.
I'm looking actually at something that Lord Keith said in a case called Arnold in 1991, where he draws a distinction between cause of action estoppel and issue estoppel, and that the public policy grounds in maintaining cause of action estoppel are stronger, he says, than in the case of issue estoppel. So there is a distinction there. So classification of what we're dealing with may be quite important.
Well, what I'm reluctant to do is to get into this debate, as it were, on the hoof. Can we consider the matter with a bit more care, and if we can provide further assistance, we certainly will do.
That would be helpful.
If it's a matter of some importance to my lords. You will appreciate, of course, that I've made my submissions already about whether or not this issue was in the frame and who could have done what about it. And the fact of the matter is that you've seen that there was specific reliance on Aarhus from the off.
Yes, yes. Mm-hmm.
The substance of the point, if not the express point in terms with the legal argument that might have featured in Ghana, was raised. We're not going to disclose assets because we don't need to, and it's not a requirement, and in any event you've got to progress. When the House disagreed with that and effectively applied what I accept as a subjective approach, in effect in its ruling in March of 2007, it was then open to my learned friend either to do one of two things, either to say, well, that fundamentally is a subjective approach and that's wrong in principle and here's why under European law and Aarhus Convention and all the rest of it, or alternatively to say, well, I say that's wrong and I've said that's wrong, but you've disagreed with me on that, and now here are my means and you can make a judgment on that basis. That was the chink of light that was left open in relation to that. So,
I mean, if you're right about the costs judge's general lack of jurisdiction, then the only thing the House was deciding was, straightforwardly, that the Aarhus Convention is irrelevant.
yes.
If you're wrong about that, and the cost judge could have considered it, then still, on the view you submit as to what we ordered, we were ordering the cost judge not to take Aarhus into consideration. So either way, it was central to our decision.
Yes. My lord, yes, that's my submission. And the question that has then been raised, that I ought to deal with, is whether or not the European position should, as it were, require you to take a different approach. Can I wait and see what my learned friend makes of the Wells case? But we would invite you to bear in mind when you come to consider Wells, which is in Bundle 1 at tab 10, could we invite you simply to note that we say you should read not merely paragraph 64, but also through to the end of 69.
Paragraph numbers again, paragraph 64.
64 to 69. And you'll see, in particular, well, even in 64, there is, in the third last line, page 363, within the report, on the bottom right-hand corner page numbers, within 64, there is already, in the final sentence, such an obligation is owed within the sphere of its competence by every organ and so on. So it's nodding towards the systems that exist in the domestic legal structure. It's not saying you have to break and remould the domestic systems.
Sorry, which paragraph is that?
64
In Wells?
Yes.
in Wells, page 363, bottom right-hand corner.
Sorry,
You may be in the Advocate
I've got the Advocate General, yes,
Yeah.
that's right.
364, final sentence, paragraph 64. Such an obligation is within the sphere of its competence by every organ. Do you see that?
Yep.
And a similar point is being made and is returned to in paragraph 67.
65 as well.
65 as well. I mean, it runs through, that's why I said read it to the end of 69, is for the National Court to determine whether it is possible under domestic law and so on. And then the line of authority you see in paragraph 67, the Peterbrook line, which says it is permissible for domestic systems to have, as it were, their own procedural rules within which these rights are to be given effect to.
Yes.
But what happens if the procedural rules don't give effect to them?
Well, then you have to, one does what one can in any event through leasing and principles of that kind, but ultimately it is for the domestic systems to design what they've done, and if you can't give effect to it through the domestic systems, then one is left with whatever remedies are available, maybe damages, but there is a limit to what one can do in effect.
But you say one thing we could do, if we thought it necessary to do, is reopen the decisions we've already had, refer the matter to Luxembourg, and, if necessary, change the order.
Well, my lord, you could certainly. I made my submissions on your having jurisdiction to reopen. The question, I suppose, would be before one jumps immediately to reference, however attractive that may be. The question, perhaps that first has to be answered, is whether or not, in considering that jurisdiction to reopen, which undoubtedly exists, you are convinced that on the facts of this case it is necessarily appropriate, having regard to all the matters that I've been through. I'm not going to repeat. If you conclude that it isn't appropriate to reopen, then you end up with a potentially of a different question that might be referred to Europe, which is whether or not you are obliged to reopen. I mean, the issue that may or may not go to Europe is conditioned by how you go through the prior domestic steps, if you are otherwise convinced.
We're presumably only obliged to reopen if we conclude that our previous decision was manifestly erroneous.
Well, yes, I've made my submissions on that, and I would say it was manifestly right. For the reasons that I've gone through, but I'm not sure adding adverbs or adjectives necessarily assists in the analysis. But the sequence is important before one gets to considering any question of the nature of the question. Otherwise, I'm sorry I've been a little long.
Not at all. Well, it was extremely helpful. Thank you very much. Mr. Marici, do you wish to add anything? Thank you.
Well, I'm grateful. My Lords, you have on the desk, I hope, and reference already been made to it, to the short analysis we did of other language versions, highlighting in particular 3 alternative language versions of the key passage that occurs in Article 10A of the EIA Directive and Article 15A of the IPPC Directive.
I'm not sure I've found it. Yes, I've got it now. Article 10A.
I think it's possibly that to which my Lord Mounts has been referring in noting the word excessively.
They're not very good translations, it seems to me. They fail to take account of the fact that continental languages use the present in an imperative sense, i.e. it should be the relevant procedures are led through, actually should be the relevant procedures are to be conducted fairly, justly, speedily, and not excessively expensively. That sort of
that may be right.
Point applies all the way through.
That may be right. It wasn't actually that document I was going to take you to at this point. It was behind that. You have a copy of the PPC directive, which is actually the directive which did the amending of the EIA and IPPC directives.
Yes.
The relevance of it, for my purposes, is in the recitals and in Article 1, the objective, and simply to make good what I suspect is obvious, which is that the relevant amendments were done, at least in part, to secure compliance with the Aarhus Convention. You see that in recitals 5, 9 and 11, and then in Article 1, the objective of this directive.
As a matter of interest, why do you head the paper Article 10A?
There should be two things that have been clipped together. They're not.
This is 15A in this one.
I'm sorry.
It's 15A, isn't it?
It's 15A in the IPPC directive,
yes.
but the phrase used is exactly the same.
Right.
And what you see in the document I've just drawn your attention to is that if you go to paragraph 7 of the PPC directive, it's the one that inserts Article 10A into the EIA directive.
Right.
So this is the directive that took the words from Aarhus and put them into the relevant effective directives, the EIA and IPPC directives, which is 10A, the one we're concerned with.
Right, thank you.
My point is the simple overarching point that what's going on here is the European Union organs giving effect to the Aarhus Convention. With that in mind, can I then take you to what you haven't actually seen so far, which is the Aarhus Convention itself, which you have in tab 29 in the third legal materials bundle. And to the recitals to that directive, because whether or not it was these recitals which Lord Justice Sullivan had in mind when he said what he said about the inherent public interest in play here, certainly bear very strongly on that point. If you look at page 867, the foot of the page, these are recitals for the convention. You go to the 7th recital, which starts recognising also that every person, do you have that?
Yes, halfway down.
Recognising also that every person has the right to live in an environment adequate to his or her health and well-being, and the duty, both individually and in association with others, to protect and improve the environment for the benefit of present and future generations. So there's a duty on individuals to act. We see that followed through in the next recital. Considering that, to be able to assert this right and observe this duty, citizens must have access to information, be entitled to participate in decision-making, and have access to justice and environmental matters. So that is to give effect to their rights and duties. And then on the facing page, the 5th recital links that specifically to judicial mechanisms, concerned that effective judicial mechanisms should be accessible to the public, including organisations, so that its legitimate interests are protected and the law is enforced. And then following from that, Article 1, the objective is in order to contribute to the protection of the right of every person, ... each party shall guarantee the rights of access to information, public participation to decision-making, and access to justice and environmental matters. We say that not only makes good the inherent public interest in these proceedings, or these types of proceedings, it also is a very powerful indicator of the objective nature of the approach to be taken. Because when one comes to Article 9.4, and I won't take you to it in any detail, it is there requiring the member state, the signatory state, to secure, as part of the access to justice provisions, not prohibitively expensed proceedings. And we say, picking up the thread of the recitals, that's to enable every person to participate, whether they be the poorest or the conspicuously wealthy, and also to vindicate their duty to do so. And Mrs. Palakropoulos, in no uncertain terms, would say she stepped forward here to vindicate that public interest pursuant to a sense of personal duty.
Does that address the phrase itself? Because let's go back to the point which I think I was putting to Mr. Eady, that one assumes that there is an ascertainable, predictable system in place to reassure the public that if they do take the step that's indicated in performance of the duty, there will be something there to which they can appeal, which will avoid it being prohibitively expensive for them. If you look at it that way, then when you get down to the crunch of deciding whether it is prohibitively expensive for them, you're looking at it subjectively. The system itself could be designed for everybody, but it could be sensitive to the individual.
Well, it could be, but it has to nonetheless enable every person to do that, because what they are vindicating is a public interest rather than, in any sense, a private interest. That's the critical element to it. So whether the person from the village or the community or the street who steps forward is the rich member of the community or the poor member, the system has to generate their access to justice, absolutely regardless. And there should be no penalty for the fact, to pick up the point Lord Mance made earlier on, that the person who steps forward has a particular personal commitment, because this is back in the territory of vindicating the inherent interest in judicial scrutiny of those challenges which cross some arguability threshold, and we protect that in our system by the Judicial Review Permission threshold. My Lords, you've seen, because Mr. Eadie took you to it, the process whereby Mrs. Palakaropoulos came to be substituted for Mr. Edwards in the Court of Appeal, but I think you haven't seen, if I can just take you to it very briefly, is the very early skirmish in the proceedings. It's at page 192 in the materials bundle. It's the argument before Mr. Justice Keith, because
192 in what?
192, A192 in the materials bundle.
Yes. It's behind tab 8, I think.
Behind tab 8, exactly. What had happened here is precisely the sort of thing that my Lord Brown contemplated, which is that an individual who was eligible for legal aid had been identified and had come forward, and what the challenge that was taken at this stage as effectively at a permission hearing point by the defendants was to say that that was an abuse and that he shouldn't be allowed to pursue the matter because he had come forward in that way. That was rejected by the judge, and I don't take you through the detail of the argument. I simply draw your attention to paragraph 9, where what is very clear is that there was a wider concern here. The relevance of this is slightly oblique because the point is no longer argued, but at many stages, and I'll show you this in a second, of these proceedings, the defendants have asserted that this was Mrs. Palakaropoulos on a one-woman campaign, and there was no wider public concern about the point. What we see in paragraph 9 is that very much wasn't the position, that there was a much wider concern here, and that was why, in the first instance, Mr. Edwards and then latterly Mrs. Palakaropoulos came forward to vindicate that wider public concern and interest. In terms of the legal aid position, my Lord Brown has asked about eligibility. We've had placed on your desks, and I don't propose for a second to take you through it, but a clip of materials which show you two things, essentially. I won't go through it in any detail. The first part of the clip is headed Volume 2F, Financial Eligibility of LSC Manual. That shows you the sheer complexity of the financial calculation which is done, and which the respondents say is something which judges should now do under their subjective approach. They contemplate a financial evaluation of perhaps similar complexity to that. Behind that are examples of the sorts of forms that have to be filled in, the sort of detail that has to be gone into. I can give you a much easier way of getting some sense of where the eligibility thresholds lie, though. If you turn to the first Sullivan report, which is in Bundle 3, if you go within it to tab 33, and within that, if you would, to footnote 33, which is on internal pagination 15, there is a very brief, and you'll now appreciate very superficial, given that you've now seen the complexity, overview of the sorts of levels of financial eligibility for legal aid.
What's the page number of the bundle?
1075.
1075.
75.
These are various
But essentially, there's a income and capital limits, which have been grossly oversimplified for the purpose of that footnote. But what you see is the really relatively low levels of income or capital that somebody needs to have or not have to be eligible for legal aid. Mm-hmm. One of the features of this case, both today and indeed over the last few years, has been the changing landscape that there has been, as you've seen indicated today, both in terms of the Irish Convention and in other ways. What Mr. Eadie essentially seeks to persuade you to do, I think, is to say, well, this is all going to be sorted out by some government process in the future. Things will come forward. No doubt they will come forward. But that doesn't remove the fact that DEFRA and the Environment Agency continue to pursue Mrs. Palakaropoulos, indeed have brought this matter to your lordships to do so. So the fact that there may or may not be a solution in the future has not dissuaded them from seeking to extract some £80,000+ from her. That shift in their position has come against the backdrop of a number of dramatic changes. You've seen some of them, for example, in the Aarhus Convention Compliance Committee materials. One you haven't seen, though, is the decision of the ECJ in the Irish case. And I'll just take you briefly to that. It's at tab 19 in the second legal materials bundle. These were proceedings in which the Commission challenged the non-implementation by Ireland of various aspects, including the ones in play here, of the EIA directive. And on the point in play here, it came as the fourth argument. If I can ask you to turn to page 581 in the printed numbers at the bottom of the page. Paragraph 78, you see, in its fourth argument, the Commission raises the same failure to transpose as regards the requirement that any such procedure must not be prohibitively expensive, pointing out that in relation to costs, there is no applicable ceiling as regards the amount that an unsuccessful applicant will have to pay, as there is no legal provision which refers to the fact that the procedures will not be prohibitively expensive. The Irish costs rules for these purposes were essentially the same as ours, in giving judges a wide discretion, but also in not specifically having implemented in express terms the wording of the Aarhus Convention or EIA directives.
It was possible to ask for a PCO, was it, in Ireland?
It was in theory possible to ask for a PCO. Ireland's answer was more in the judicial discretion at the end of the case, yes, than in the potential position of a PCO. We see the fourth question answered, or the fourth argument answered on page 583. The point I've just made, judges still have the discretion, you see this by paragraph on the left-hand side 93, well, it's common ground the Irish courts may decline to an order an unsuccessful party to pay the costs, and can in addition order expenditure incurred by an unsuccessful party to be borne by the other party. That is merely a discretionary practice of the court, same as here. That mere practice, which cannot by definition be certain in the light of the requirements laid down by settled case law of the court, cited above, cannot be regarded as valid implementation of the obligations arising from Article 10A, etc. I'll return to that in a few minutes, but the...
Can you just refer back to 54 and 55? We're looking back to paragraphs that require precision, specificity and clarity and so on and so forth.
Exactly, in the implementation of requirements of directives.
Yes.
General propositions of European law to say you can't simply rely on administrative or judicial authorities in exercising their discretion.
Yeah.
Why is that? Is it because they believe that the discretion might be used to require people to bear prohibitive costs?
Well, in the specifics of this example, presumably yes, but in the generality, it's a general failure to implement the directive, to rely on...
well, so what you have to do is you have to have a provision of the law which says you can never recover prohibitive costs.
Or something to that effect. I mean, the European organs wouldn't be so specific as to say this is what you require because of the implementation discretion of the member state.
The phrase that's used is, and looking at 55, is the person's concerned must be enabled to ascertain the full extent of their rights. That seems to be the overriding test. But then one comes back to the question, how far does one need to go in doing that? Do you need to identify the system which will give them their rights, or do you have to actually go to the final figure so that they can ascertain before they become embroiled in proceedings? It seems hard to imagine that at the very outset you have to have a figure in your mind before you actually write the crucial letter to start
Or
proceedings.
alternatively, perhaps a formula or a set of rules.
Yes,
So that you know at the outset what your risk, what your exposure is.
yes.
That doesn't, I appreciate, answer whether it's to some extent subjective or objective, because you might have a formula that says, depending on your financial situation, you might have a different exposure, but at least you know what it is. Now,
But is prohibitive expense itself sufficiently certain for this purpose?
Well,
Whether it's objective or subject, let us assume that that problem has been resolved.
well, it depends slightly what the answer to that question, though, is, I suspect, because if the answer is it's objective, then that may lead, as we see in the formulation Lord Justice Sullivan uses in Ghana, to some notion of an ordinary person and some perhaps benchmark approach to that. If the answer to the prohibitive expense question is subjective, then it may not itself be sufficiently certain. So that may reinforce the notion that you need a more objective approach, because otherwise you don't get the certainty unless you have some either judicially imposed or statutorily imposed formula at the outset. But all of this is no doubt what's important.
Either way, you're never going to get further than say that costs can't be for these proceedings and this issue prohibitively expensive.
That's right.
Are you? I mean, you could never have all environmental claims. The limit of costs is £5,000. That just wouldn't. Are you suggesting?
Well, you may or may not. I don't need to.
I just wonder whether they misunderstood what discretion means here, because supposing you put in your rules as a matter, or supposing you had a judicial rule that the discretion must always be exercised to comply with the Aarhus Convention, which one would have thought was actually the principle, would they really say that because that's the exercise of discretion, it's invalid? Because if they do say that, then effectively it's not going to be good enough to put in our rules something along the lines of Section 19 of the Access to, is it Section 19 of the Access to Justice, 11 of the Access to Justice Act.
Well,
that won't be good enough.
I don't take this too far, because in one sense, for today's purposes, because in one sense it is pointing to, at least in our system, to an early ascertainability in the rules, which is perhaps what the government's contemplating in amending the rules. And that is one of the drivers, no doubt, for those changes, along with the concerns expressed by the Aarhus Compliance Committee. My simple point is this, that in Mrs. Palakaropoulos' case, she has never had that certainty, because she has had exactly the difficulty facing her, which is contemplated there by the judges, because we don't have, and we certainly didn't have in 2007 and 2008, even a rule which said the cost shall not be prohibitively expensive. So, in fact, our system has never delivered for her compliance with Ireland, whether you read it narrowly or widely. And that may be one of the things that focuses attention on the arguments that were before and the deliberations of Your Lordship's House in 2007 and 2008, because those points predated the decision of the ECJ on any view. And that is part of, if you like, the many things which have changed. So when you come to consider, as I will invite you to do, whether you are bound by, and if so, whether you need to revisit your earlier orders, this is part of, and perhaps a key part of, the impetus for needing to do that.
And you're approaching this on the basis, are you, that it's not a res judicata point, but an estoppel point?
Indeed. But actually, even if, what I'll come to show you is that even if, as long as we're right on the cost officers having jurisdiction, actually, your Lord's order in 2008 simply said, carry on and do what you've got jurisdiction to do. It didn't constrain them in any way to deal with the Aarhus Convention, because your Lordship's order, as they themselves have now said, and we support their reasoning in this, didn't preclude application of the Convention. And indeed, if they have jurisdiction, your Lordships can simply be taken on one reading to say, do your assessment, bound as you are, to give effect to, amongst other things, the Aarhus Convention.
But I mean, even if that's wrong, and even if it's res judicata and there's no power in the taxing officers and the assessment process, I mean, Lonro, you would say, would found our jurisdiction to reopen.
Yes.
Not Lonro, I'm sorry.
Broom and Cassel or
Yes,
Pinochet.
yes,
or,
or
yeah.
Pinochet.
Yes.
Pinochet.
Yes.
So we say whether it's issue estoppel, res judicata,
Yes.
whether you were right or wrong, I say, putting it delicately, it needs to be revisited in the same way. Can I then pick up this question of cost officer jurisdiction? You have in the bundles at tab 9 Marks and Spencer, in volume 1, tab 9, paragraphs 24 to 27 of that, I don't take you through them because they're well understood, well-travelled principles which require...
Can you give the paragraph numbers again?
I'm sorry, 24 to 27.
24
to 27.
and
They bring together in a helpful single place a number of principles, including in 24, as it runs over the page, leasing.
this is page 310.
310 running to 311. 24 directs you to the well-understood principles in leasing. And then 25 to 27 illuminate the further obligations of the court to secure compliance with the directive. I'll come back to Wells in a bit if I may. But what we do say, applying leasing, etc., is that whether or not coming at it through the purely domestic eyes, you would have reached the conclusion about words like proportionate and reasonable, bound as you are to give effect to leasing, or the leasing doctrine, unless the words preclude you from reading into the costs officer's jurisdiction the ability to give effect to the directive, then that's what you need to do. And we say the words very much do not preclude you.
Why do we, if the court has the jurisdiction, leasing only applies when that's the only way to comply.
Yes.
Well, if the court can exercise the jurisdiction satisfactorily, and in fact we should have done so, you would submit in our original orders, you don't get to that point.
In some sense, this is my belt and braces submission, because I say that whether or not leasing requires you to do it, you can do it anyway. But if there was ever any doubt about it, Mr. Eadie would certainly have you say there is doubt about it, that then leasing would drive you to that result.
I understand this to be an answer to the point on the rules.
Yes.
The order, it takes you to the rule. The rule states it's to be the standard basis. You say, well, that's fine, but you've got to read it along with leasing, and that opens up the jurisdiction on the wording of the order which didn't prohibit them doing that.
Yes, I'll come to your Lordship's earlier orders in due course, but in my submission, the more logical approach, which is the approach that Lord Mance contemplated with Mr. Eadie earlier on, is to say, well, have the cost officers got the jurisdiction in the first place? If they have, whether on a natural reading of the statutory provisions or through a leasing pair of spectacles, are they precluded by your Lordship's earlier orders?
Yes, but you don't answer the question whether they've got jurisdiction by reference to European law unless it's necessary to do so. It's not necessary to do so if the court actually has jurisdiction at the conclusion of the proceedings.
Absolutely. I'll take you in a minute to the rules which explain in my submission that the cost officers and therefore this court does have jurisdiction. Leasing is simply the fallback that says if there was any doubt about that, then compliance need to be secured that way. Can I take you very briefly to the rules? You have seen them. They're in tab 20 in the second bundle. Rule 51.1 on page 597. As you know, the cost officers saw their jurisdiction as coming through the question of reasonable in amount. Well, we say it's not limited to that. We say, firstly, at the most general level, that the provisions of Rule 51.1, and just keeping a finger in that, if you could look to the practice direction, which is in tab 21. It's practice direction 16.1 at the foot of page 604. Recognise a wide discretion. 16.1 says, bear in mind the terms, unreasonably incurred and unreasonable amount. I must read 16.2 and 16.3. 16.2 refers to the length of the hearing, the complexity of the issues, as indicated by the judgments delivered by the court, and the general level of fees sought and allowed in lower courts are taken into account. and then 16.3 deals with how you assess council's fees. But the point about that is that none of that is an exhaustive list of considerations, and nor is Rule 51 sub 1 on page 597. But even if that were wrong, we still have the concepts of proportionate to the matters in issue and are reasonably incurred and reasonable in amount. Now, the cost officers saw this as coming through the prism of reasonable in amount, and that led them to contemplate, and I say that advisedly, an assessment on a line-by-line basis. I say to contemplate because, of course, they didn't actually make a decision on this third issue.
Is that coming through paragraph 17 of their reasoning?
It is. They contemplated but didn't answer this third question of how they would actually go about the exercise.
Yeah.
And we say they were potentially right on reasonable in amount, but actually one gets to the same place through the prism of proportionality. You've seen already Leahy and Pirelli. Can I just ask you to look back at that? It's in tab 13 in the same bundle. Pick it up, if I may, first of all at page 438. This, of course, was dealing with a request to reopen by reference to the conduct of the parties. And in my submission, what's being referred to in paragraphs 20 and 21 is that the question of conduct of the parties is very much a matter that the judge in the trial would have sight of, and not something that the cost officers would have sight of, whereas, as it says in the middle of paragraph 21, he does not have the advantage accorded to the cost judge of having a detailed bill of costs. So what is being said there is you can't reopen conduct questions because they're paradigm questions for the judge who's dealt with conduct. That doesn't in any way preclude the reverse situation, which is perhaps why the cost officers here actually expressed the view that it was preferable for cost officers to deal with these matters than for the judge at the end of the trial, precisely perhaps because they do have access to the financial information. They would know, for example, what amount of cost was being claimed, and therefore would have a better idea of whether it fell foul of the Aarhus principles. And of course, can I just, before I get too far into this, everything you've heard in the course of the day points to the benefits, the preferable situation of dealing with this Aarhus compliance question at the outset of proceedings, whether it's protective costs orders or some similar position. That may well be the best way of doing it, but that doesn't in any way preclude either costs officers generally or this court in this case from dealing with it where it hasn't been resolved before. The other paragraph you looked at in Leahy and Pirelli was on the previous page. It was the extract from Lord Wolfe in the practice direction, where he's dealing with the CPR, and he precisely identifies the two-stage approach, firstly dealing with a global approach and then dealing with the specifics of the individual items. You see that just beside letter E on page 436. And what he says there is, having regard to the considerations which CPR 44.53 states are relevant. My lords, you have those in tab 22. You have them on page 673. .51. The court is to have regard to all the circumstances in deciding whether costs were on the standard basis proportionately and reasonably incurred, or were proportionate and reasonable in amount. So all the circumstances. And then if you drop to 44.53, the court must also have regard to, and then little b and c, amount of or value of any money or property involved, and then importance of the matter to all the parties. Now that's the element which perhaps one draws most quickly from it, which is proportionality to the issues in play. And that's what I think came out in the discussion earlier in the day.
But you say these are hugely important matters.
These are hugely important matters, but
On
even
the
even
face
if
of it, therefore, the costs will be proportionately high.
even if whatever one view one takes about the importance of the matters, the critical point from my purpose here is that when looking at proportionality, you are looking at all the circumstances. This is very much a non-exhaustive list, and all the circumstances is plainly capable of including the fact that these are Aarhus or EIA proceedings. So in other words, when the judge comes to decide, or more particularly the costs officer comes to decide proportionality, he or she is entirely capable of taking into account through the prism of proportionality the fact that these are Aarhus proceedings and the fact that therefore there needs to be compliance with the prohibitive expense obligation. So there are at least three different ways where one can, quite permissibly, as the cost officers saw themselves as able to do, deal with prohibitive expense through the prism of their powers. There's no submission, no question in my mind, my submission, that there's a restriction on that. But even if there were...
It doesn't trouble you that this is the exercise of a discretion?
Well, it does in the Irish sense, because Ireland would say you need a system which deals with these things at the beginning of the process. But that doesn't preclude dealing with them at the end of the process if they haven't been dealt with before. No doubt that the government's going to put in place a regime which will try and deal with these things at the beginning, because that's what, for all sorts of reasons, makes complete sense. But in a case such as this, where that hasn't happened, the trial judge, and then more particularly the cost officers, has to have the ability to cure the problem, and that's what we say needs to take place here, and can, on a proper reading of the rules, do so.
Well, I think my only point is that it's inevitable, if you're going to approach it this way at the end of the case through the costs assessment mechanism, that you're going to be relying on the exercise of a discretion.
Well, in fact, that must be right, yes. But the fact that we're here having to rely on a discretion to deal with the compliance with the convention doesn't take us outside the requirement to comply with the convention. It simply means that the discretion has to be exercised to that result. It doesn't negate compliance, it drives compliance in a particular way.
How do you take account of your own costs? Is the court required, by reference to these considerations, to say that this was very important to you, to Mrs. P, if you'll excuse me, shortening the name, Palikaropoulos, and that it was a complex matter, and that the skill, effort, specialised knowledge and responsibility involved, it meant that a lot of time and money was spent on her side, and in order to ensure access to justice, the other side should get correspondingly less. I mean, there is a problem here. I don't quite know how one deals with that.
I don't think there's any dispute in this side of the court that when one looks at prohibitive expense, one needs to deal with all costs. It's both sides of the cost, or at least they're taken into account. Now, we say that matters because one of the submissions that's made against us is to say, well, in effect, she's already been able to pay her lawyers, therefore she can clearly afford to pay more lawyers. In other words, the other side's lawyers. We say that's fundamentally the wrong way round, or the wrong outcome.
Well, clearly that would be doubling the burden, but there is a problem. I mean, what does the court simply allow a claimant to spend as much as the claimant can, or is willing to, on the claimant's own lawyers, leaving it correspondingly more difficult to make any order against her?
Well, that may be the result, but there's no doubt that the prohibitive expense is the cost, all the costs that they incur, so their own costs and the other side's costs to which they're exposed.
Or I mean, I suppose if it's objective, what you ought to say is, looking at this litigation is what is worth, should be possible to conduct it on both sides with this amount, and fix a figure that gives it equal amount to each side.
There may be lots of ways of doing it, both systemically and in a particular case. But that's in a sense, that's precisely why we say, and precisely these debates are why we say this point is not act clear and needs a reference. Because these are precisely the sorts of debates that you've seen have been thrashed around between judicial and non-judicial commentators over several years. In terms of the arguments deployed against me as to why the costs officer shouldn't have this jurisdiction, there are a number of them. I've touched on a couple of them already. One of them that's identified in the respondent's written arguments is to say that the costs officer shouldn't have this jurisdiction because, in fact, the person hasn't been deterred. Now, that is simply to get one immediately into the subjective-objective question and doesn't answer the position. They then say that prohibitive expense is necessarily prospective, and they parade that as an argument for why cost officer shouldn't have the jurisdiction. Again, I say that's no answer, because again it simply goes into the subjective-objective question. But it also conflicts with the submissions that the government, in fact, indeed the same government department, DEFRA, has made the Aarhus Compliance Committee, making very clear that judges in their submission do have the discretion at the end of the case. So whilst it may be a good thing for this to be dealt with at the outset of the case, as a matter of policy, their case has been that judges do have a discretion. If I just give you the references for that, yeah. It's in the government submissions in tab 32, paragraph 72, and then 116. And you see it referred to in the Aarhus Compliance Committee.
Could you give the page number so we can find this? It's a very lengthy document. Paragraph 72, did you say?
It's 72.
Page 997?
116.
No, what?
72 is on page 997, yes. And 116 is on page 1014. And indeed, at 1014, you see that the discretion that they identify in that submission, if you look at 116 sub B, flexible rules of courts, giving the courts a wide discretion to deal with costs, including whether to order costs, the assessment of the amount of costs, as well as protected costs orders. So, including, therefore, the assessment of costs, if you look at the top of 1014.
Well, I mean, it's hardly a contention that it can all be left safely to the taxing officer, even though the court itself refuses to qualify the costs order.
Well, plainly that's not the ideal situation, but that's the difficulty is that Mrs. Palakropoulos is in the position she is, and we say there's an obligation on the court to give effect to the directive, notwithstanding the fact that it perhaps would have been better if it had been done at some earlier stage.
I mean, you're really saying that the obligation is to make use of the best that is available just now to achieve the result.
Precisely. And that is Wells. I'll come to Wells in a little while. In terms of your Lordship's previous decisions, if I can deal with them briefly in chronological order, one of the things that has changed quite notably through the course of the case is the defendant's submissions. If you go within the materials bundle to tab 9, page 38, this is the Environment Agency. You'll appreciate that there were parallel submissions and sometimes joint submissions from the Environment Agency and DEFRA. This is the Environment Agency's written representations at the PCO security stage. Page 41, you'll see that in the middle of the page there's a heading Public Interest, that they very much took the point then, and you'll see it again in a moment the following year, to say these are not public interest proceedings. But firstly, what you now see is that, as Lord Justice Sullivan has recognised in Ghana, there's an inherent public interest. That was precisely what the judge at first instance fell foul of in Ghana, because he said there was no public interest in the case and therefore no PCO was going to be granted. The Court of Appeals said there's an inherent public interest. You haven't seen this paragraph, I'll take you to it in a minute, to the effect that the judge shouldn't have worried about that limb of the corner house test. But you'll see the defendants resisting the PCO at that early stage by reference to public interest concerns. We say they're factually incorrect anyway, but they're now clearly legally wrong. And you're also, again, picking up what the government said to the Aarhus Compliance Committee, back in tab 3.
Volume 3?
Volume 1, tab 3.
Sorry, 1-3. Right.
No, I'm sorry, you're absolutely right, my lord, it is volume 3, of course. Volume 3, tab 32. Paragraphs 61, which is on page 993, and then 65, which is on 995, presenting to the Aarhus Compliance Committee a very relaxed approach to public interest requirements, effectively talking down that limb of the PCO test. Now, it's that latter position which is correct, but you see the submissions that were being made to your lordships back in 2007. Then still on page 42 in those submissions, the middle of the page, under the heading the applicant's resources, the submission is there being made that Mrs. Palakropoulos' means are of central importance.
Sorry, which paragraph?
Middle of paragraph, page 42. It's almost bang in the middle of the page. Heading of the paragraph is the applicant's resources.
Not sure I found that.
I'm sorry,
And you're back in the other bundle now.
Oh, I see that one, thank
I'm
you.
taking you through their representation.
Yes. So the bundle page number is
42, tab 9, page 42.
42. Yeah.
Yeah.
They are argued, and this to some extent supports Mr. Eadie's suggestion, or my Lord Mance's suggestion, that this narrow question may be issue estoppel, the question of subjective objective, but it plays straight into that question because their contention was that her means were absolutely central. And then the last key point in those representations on page 43, under the heading in the middle of the page, again, Public Participation Directive, they say, Mr. Buxton asserts that the directive points strongly towards Mrs. Palakropoulos not exposing herself to more than her own legal costs at legal aid rates in the present case. In effect, he argues that a consequence of the directive is that the respondent should be denied their reasonable cost of defending this appeal even if they are successful. In effect, they were resisting any suggestion that the Aarhus Convention and the EIA directive could lead to downward pressure on the respondent's costs. And yet, very plainly, their case to the Aarhus Compliance Committee and to this court is to recognise that there precisely can be a reduction in the respondent's costs in such a case. So in four key ways, the submissions they made have now been overtaken by a much more nuanced understanding of the legal position. In terms of my Lord's order at that stage, we simply adopt what the cost officer said about it. It's at page 48 in the same tab. It didn't in any way preclude later consideration of the prohibitive expense question, and indeed, in 2008, the respondents didn't make any such suggestion. They in no sense said, you are precluded in 2008 from doing this because of what you decided in 2007, and they were plainly right not to make that submission. So I say no more about page 48. In terms of the decision on costs at the end of the case, DEFRA's submissions for this are at page 58 and following. And they make very similar points, if not identical points, to the ones that you've already seen. First of all, on page 63, paragraph 13, they make the absence of public interest point, 13A. And they pick that up, foot of B, running over the page. That's effectively what we now know from Ghana to be a bad point. Then at 13G, which is on page 65, they make the point at the foot of paragraph G, which is, as your lordships will imagine, fiercely resisted on a number of grounds. in essence, these proceedings constitute one relatively affluent and committed individual's private campaign. Well, both in terms of what it says about her position and in terms of the wider interest, that is fiercely resisted, as you've seen on the facts. But the point is, again, very much driven by a subjective approach. Then on page 67, paragraphs 15 and 16, they make the same point again about the directive and resist the proposition that it provides any downward pressure on respondents' costs, which again they now abandon and in any event is plainly wrong. And then finally on the foot of page 67 running over to 68, in terms of mechanisms identified for compliance with the directive, or this aspect of the directive, they say this, the very last words on 67, the cost of litigating environmental issues in the UK is minimised by inter alia, the availability of legal aid and protective costs orders. So what they're essentially not recognising is the role of the judicial discretion at the end of the case, which, as you've seen in their submissions to Aarhus at least, they very much now do recognise. So in terms of the way the case was put, but by DEFRA, it's a very different case to the case that's now put. And we say that was a key background to my Lord's analysis of the position, which we then see on page 99, which the order is on page 99. And we say this order doesn't in any way stand in the face of the cost orders having the jurisdiction in this case to deal with the matter, because if they have jurisdiction in principle, which I've submitted that they do, and if they are obliged by European law to exercise it consistent with the Convention, which I submit, then for your Lordship simply to say, go away and assess the costs, the usual order, is simply to pave the way for them to conduct that exercise. As the costs officer said in their decision here, that doesn't in any way preclude that process. Had your Lordships in July of 2008 said in effect, go away and do the exercise, but don't have any further regard to the Aarhus Convention because we've dealt with that, or the EIA Directive paragraph 10A, Article 10A, that would have been very different. This precisely leaves open the position. Of course, that's premised on them having the jurisdiction to do it and the obligation to do it, which I've already dealt with. But we do say, if there's doubt about that, firstly, your Lordship's order needs to be construed and in effect on a mar leasing type basis to give effect to European law rather than to preclude its application. But in any event, by way of a long stop, we say your Lordships would be obliged, if necessary, to revisit that. It's accepted that you have the jurisdiction to do it. Can I just pick up for a moment the Pinochet case? The respondents accept that you have the jurisdiction to do it, and in the extract from Lord Brown Wilkinson, which you were looking at, I agree with what I think was Mr. Eadie's analysis of it, which is that what's there being identified is a jurisdiction to correct any injustice, and if you like, a self-practice direction, which explains how the House will generally do that. So if it now requires the House, or this court rather, to revisit that last paragraph by letter F, which says it should now be clear, it should be made clear the House will not, if there's a necessity to revisit that paragraph, well, that needs to be done. But what is clear from the earlier paragraph, and I think agreed between the parties, is that there is jurisdiction to do it. And we say Wells requires you to do it. If I can just pick up Wells for a moment, it's in tab 10 of the legal materials.
Tab 10?
first bundle. Paragraph 64 explains that it's clear from settled case law that under the principle of cooperation in good faith laid down by the treaty, the member states are required to nullify the unlawful consequences of community law. That is the obligation. I'll take you in a second to Humblet and Frankovich very briefly. The overarching obligation is to nullify the unlawful consequences of community law. That is owed by every organ of the member state, including, we see this from 65, the court. And then the paragraph Mr. Eadie jumps onto is paragraph 67, which says the detailed procedural rules applicable are a matter of domestic legal order. Well, the detailed procedural rules being referred to there are the procedural rules for doing what 64 and 65 have told you to, which is to nullify the unlawful consequences. So that's telling you that the way you do it has to comply, in our instance, with the procedural rules that one gets from Pinochet, which in effect is simply an open power in this court. Paragraph 67 is not somehow referring you back to the domestic costs regime. In this context, it's referring you to your power to do what 64 and 65 tell you you need to do.
So the cost judges should be saying to the House of Lords, your order's unlawful, we're now going to nullify it.
My Lord, no. Their decision, right or wrong, and that's plainly why we're here, their decision was that they weren't precluded. It wasn't for them to nullify your Lordship's order, but now that the matter's before your Lordships, if your Lordships are of the view that the costs officers were wrong in their analysis of the earlier order, then your Lordships have the power, and we say need to exercise it, to nullify that earlier order, or vary it as it needs to be varied.
Do we?
I'm not suggesting for a second that the cost officers, had the cost officers decided that the order was somehow precluded them from acting, I'm not suggesting for a second that they could have departed from it.
I'm sorry, this argument is not, therefore, suggesting that it should now be up to the cost officers to do it.
No.
This is an argument that we should reopen. No, I'm sorry.
I'm sorry if I wasn't made that clear.
I thought you were directing it to...
So you're saying that in the jurisdiction we have under the rules to address issues of principle, which is, I think, what our function is, that is open to us to do that.
Exactly. You're exercising that issue of principal jurisdiction in relation to cost officer assessments, which is how we
Yes.
came to be here today. And we know you have power, generally, see Pinochet, to revisit earlier orders. So if in the present case, your earlier order stands in the way of giving effect to the directive, where in a general case the cost officers could have done it, if that's the view, then we say you need, pursuant to that Wells obligation, to exercise that Pinochet power in order to revisit the earlier order.
There was a method used in the Pinochet one, wasn't there, to... I beg your pardon, no, it was a panel of 5 judges at Pinochet 2. Is that right? And then it went to 7 for Pinochet 3.
You're probably right.
So the power was exercised by a panel of 5, which we are.
That's right.
Yeah.
And I don't know the question, which I suspect may be behind that, as to how many of your Lordships were involved in the earlier order. I suspect it was the full panel, but the order doesn't say that one way or the other.
Well, in practice, that's how it's done. So it would be a decision taken by all 5 on the costs point.
But as I say at the outset, there's no dispute that you have the jurisdiction to do it.
Yes.
I'm simply explaining to you how that fits with Wells, and Wells doesn't stand in the way of that in any way. And Mr. Eadie's reference to paragraph 67 takes him no further. I said I would briefly touch on the cases referred to in paragraph 64 of Wells. That's Humblet and Frankovich. If I can just do that very briefly. You have those. Humblet is in tab 2. Humblet, this is on page 569, internal pagination, page 18 of your bundle, the right-hand column. That is referring to legislative or administrative measures, middle of the right-hand column.
Sorry, which was the page again?
It's page 18 of the
18,
printed
thank you,
pages of
yes.
569 internal.
Yep.
Right-hand column halfway down.
I haven't quite found it yet. Which bit?
It starts with the words, in fact, if the court rules.
Oh, yes.
That's referring to legislative or administrative measures, but when one looks at Frankovich, which is in tab 5, it's cast more widely. Page 163 in tab 5. Paragraph 36. A further basis for the obligation of member states to make good such loss and damage, this was the damages consequence, is found in Article 5 of the treaty, under which member states are required to take all appropriate measures, whether general or particular, to ensure fulfilment of their obligations under community law. Among these is the obligation to nullify the unlawful consequences of a breach of community law, and then they refer back to Humblet. So that's put in widest possible terms, and that's in my submission apt to catch your lordship's previous order.
That can't override by itself ordinary principles of res judicata or issue estoppel. It can't mean that someone can go on endlessly arguing over and over again that in fact there was a breach of community law and you got it wrong last time and you should now hold that it was.
No, that's plainly right, and there would be a greater difficulty if your lordships were to take the view that it was res judicata than issue estoppel.
Well, that may be right, I think, but are we in, as I think Mr. Eady suggested, in Köbler territory, i.e. would the question whether we were obliged to nullify the unlawful consequences of a breach of community law depend upon whether it was manifest that our previous order was wrong, or whether our previous order was manifestly wrong.
In my submission, not. That's the gateway into a damages claim after the event. It's not a constraint that applies in the present situation where we are still in the same proceedings and we're asking the court, as a long stop if necessary, to exercise the power that's given to it there, or that's referred to there.
No, but let us suppose that the possible problem in this case is that it wasn't fully argued out. But let's suppose it had been fully argued out. Unless you have some sort of limitation along the lines of Köbler, as I was suggesting, you would go on endlessly re-arguing a point. So you got it wrong last time, let's have another go. You must reconsider it. What is the constraint to prevent that on your case? You say that res judicata and issue estoppel are no bar. What is the bar?
Well, res judicata may be a bar, but I say we're not in that territory. We're in at most issue estoppel.
Well, even issue estoppel doesn't allow you simply to re-argue points ad lib.
No, my lord. But the analysis, I don't go back through the reasons why I say your lordship's earlier orders were not dealing with the correct position. The critical thing here is we're in the same proceedings. We're not here trying to come back years later and reopen some old question.
I don't think that makes any difference, does it? Once you had a decision, I would have thought the possible problem or flaw in the previous decisions is that they could be said to have proceeded on assumptions. Points weren't really plumbed. And it may be said to be obvious that there was actually a point of European law which was unclear. But without something like that...
Well, Lord, if one's looking for the clearest point that your lordship's arguably decided, and this is Mr. Eady's submission, is that you arguably decided in 2007 in favour of at least a partially subjective test. We say, if necessary, that was manifestly wrong, or at least the point that's begged by the proceedings now is what does privative expense mean, and is it a subjective or objective question? It may therefore be that you can't answer what my lord's calling the Köbler question until after one's had a reference and clarified what the answer to privative expense is.
Surely the Köbler question here
applies to the question whether there wasn't a point of European law which was uncertain. If we were manifestly wrong in failing to refer an uncertain point, to detect it existed and to refer it, then that might be a way of deploying the Köbler point. You don't have to say the answer, so it is manifest. What is manifest is that there was a point that was arguable.
Well, I certainly say that, but actually in terms of the sequence of how things I think would work here, in terms of what we're proposing to your lordships, what we say is that whichever way one analyses the case, whether one says the cost officers had jurisdiction and needed to exercise it, or whether one says they were somehow stopped from doing so and therefore your lordships are potentially revisiting an old decision, that only arises in the light of the answer to prohibitive expense, which we say is manifestly something that needs to be referred now because it's not act clair. Once one knows the answer to that, one can then know the extent to which revisiting is needed or not, in the light of, with the benefit of, what the European Court has told us on prohibitive expense.
I suppose you can say, well, to use the phrase, we are where we are. We're faced with a situation which we are. I'm looking again at Lord Keith and Arnold, where he says that one of the purposes of estoppel being to work justice between the parties, it is open to courts to recognise that special circumstances, an inflexible application of it may have the opposite result. So he's saying that one's got to realise the nature of the principle, and in situations of various kinds, and he mentions some there, one may have to give way to the need to reconsider the issue, although otherwise estoppel would apply. Is that kind of line
Well, we
of
certainly
thought?
say that's certainly right. Yeah.
Sorry?
Well, that's absolutely, we say, is the position.
I mean, one answer perhaps to Lord Mans's question, would be, well, if there was absolutely nothing except another effort to argue the point again without any question of a reference, we just throw it out as an abusive process. Yeah.
My Lord, yes, and we it's not just that we're asking for a reference, it's that, as you've seen, for example, in the various things that you've seen in the course of the day, that the understanding judicially and extrajudicially as to what the position of this directive and this convention is has moved on a great deal in the course of these proceedings.
Is it just a matter of interest, and I don't spend too long on it, is it a question of res judicata or is it issue estoppel? Where's the boundary? Because on one view, there is a claim for costs which is determined against you, or a claim for costs, yes, which is determined against you. And that, on one view, is might be said to be a case of res judicata, isn't it?
No, my Lord, in the sense that your Lordship's order on page 99 doesn't say, assuming I'm right in terms of the cost officer's jurisdiction.
Well, yes, if
they have no jurisdiction, that's a slightly.
If you're wrong about that, let's
If I'm wrong
assume.
about that, the difficulties are much greater. That's plainly right.
Yeah.
My submission is that they have the jurisdiction. The question is whether they're prevented from exercising it, which is the second question. Your Lordship's order in my submission doesn't prevent them from...
Yeah, well, I've got that point. Supposing one read that it has interpreted it as ordering them to assess costs without reference to Aarhus, even if they had jurisdiction to take into account Aarhus.
Well, that would require reading words into your Lordship's order which simply aren't there. That would be the only way in which it could, in my submission, be res judicata. Yeah. And that's the way the cost officers saw it. Yes. You didn't preclude them doing what they thought they had power to do and an obligation to do, and therefore they could and should get on and do it.
I think the boundary between the two, if I might suggest, is for res judicata, it's identity of issue, identity of subject matter. And that's why in a case where one has additional material which wasn't reasonably discoverable before, you're really in the area of issue estoppel rather than res judicata, because you want to introduce something new that hasn't been considered before.
But we're not anywhere close to that territory in my submission, because there's
it's a very narrow distinction, but you're saying, well, things have changed, and therefore the issues that should be looked at now were not in the forefront of the argument last time.
That's true, but also what I say is that your Lordship's order doesn't, on any reading in my submission, as the cost officers said, and we say they were right to say assess costs without reference to the Aarhus Convention. Mm-hmm. No. That question of how you assess costs was very specifically not determined by your Lordship's order. You very specifically left that to the cost officers. It's precisely what the order says. So assuming they have jurisdiction, and that's obviously I'd have to get over that hurdle, you precisely left that question to them in an unconstrained way, and they were right to understand it that way. Can I move, if I may, to prohibitive expense? You've seen much of the material already. Can I just pick up a couple of additional points? Firstly, just in case it features in your Lordship's understanding, the question of what costs are counted in the evaluation of prohibitive expense. There's no dispute, I think, that prohibitive expense catches all the costs, both own costs and other sides' costs. You get that in the DEFRA submissions in Volume 3, tab 32. Paragraph 44, it's on page 988. The avoidance of doubt is fully accepted that it catches both costs. You also see that in the Court of Appeal in Morgan, although there's a slight, not uncertainty about it, but a slight not complete decision in it, which is volume 2, tab 16. In the Court of Appeal, page 504. Paragraph 47, Lord Justice Carnworth draws together some of the threads, and then this is the slight caveat, without attempting definitive conclusions. And the first subparagraph, the requirement of the Convention that costs should not be prohibitively expensive should be taken to apply to the potential liability of claimants, including the threat of adverse costs.
Sorry, which bit is this? I beg your pardon. 47, which part of it?
47.1.
1, yes, right.
So recognising that he doesn't attempt definitive conclusions, I mentioned that simply to deal with an argument that's in the other side's written argument, but I don't think Mr. Eadie referred to, which is in effect to say that because Mrs. Palakaropoulos has already paid her lawyers, she can therefore be expected to pay more lawyers. And I simply, in that context, draw your attention to Mr. Buxton's third witness statement, which came recently and is loose, yes, where he explains the financial predicament of firms like his. And he reminds the court of what my Lord Hope said in the JFS costs case.
It's a second witness statement, I think.
Second witness statement, and it's the page 8. And I don't take you through it, but he reminds the court of what my Lord Hope said in JFS, the costs part of that rather than the substantive part, and the impact of downward pressure on claimants' costs on firms like his. I simply put it in the most summary form. And just to give you the reference, in tab 9 of the materials, tab 9, page 7, paragraph 21, you see that Mrs. Palakaropoulos' lawyers have been acting at rates equivalent to LSC risk rates.
That's right.
I don't ask you to turn it up, it's a very short paragraph.
Page?
It's tab 9, page 7, paragraph 21. So what she has paid, she's paid at very reduced rates. Then, if I may, still on prohibitive expense, look at Ghana. That's in volume 2, tab 17. You've seen much of it already. You haven't, I think, been drawn to page 526, paragraph 39. That's the paragraph where, I mentioned it already, where Lord Justice Sullivan identifies the inherent public interest, paragraph 39 on 526.
Paragraph?
39 on 526. He identifies the inherent public interest in these kinds of proceedings, and that was why the judge below was wrong to rely on that limb of Cornerhouse, in rejecting a PCO. And my submission, that then correctly informs his view at 46, which you have seen, about the subjective-objective approach. And what he does there is he clearly, and we say correctly, rejects the purely subjective approach. And, my lords, that, of course, is exactly what the respondents contend for here. You have that put very pithily on in their application to this court. If you, just to give you the reference, it's in their grounds of application to your lordships on page A27 at paragraph 58. They say in terms, it's submitted that the prohibitive expensive test is and should be focused exclusively on the actual circumstances of the parties to litigation. So that's the purely subjective test. So that's flatly in the face of what Lord Justice Sullivan and the Court of Appeal considered to be the position. He keeps an open mind on whether the test is purely objective or whether some regard can be had. And in my submission, the some regard is a nod to the department store owner or the wealthy footballer. It goes no further than that. And he then picks up and refers to, and this is paragraph 50, the position of the ordinary member of the public. And in my submission, what's there in mind is the vast majority of people who fall into, in his rubric, the ordinary member of the public, but with a possible exception, and you'll see how this is picked up by Lord Justice Jackson in a minute, for the conspicuously wealthy. Not some general subjective means assessment type test. Um, 51 to 52, he expresses concern about the potential intrusive means assessment that would be required. We say that's a very powerful indicator against a subjective test, and he's right to put it in those terms. The respondent's answer to that is to say, well, it could be done in private. And we say that's not an answer, because firstly, there's the chilling effect of having that assessment done. But also, if I can show you, my lords, the sort of thing that respondents have in mind, you have in the bundle, again, part of the application for these proceedings, at page A28,
Yes, the annex.
the annex, a series of questions that they say Mrs. Palakoropoulos should answer, and no doubt they have in mind should be answered as part of the means assessment for a subjective approach. My lords, we say, first of all, that is fiercely intrusive and inappropriately so, and secondly, it's a recipe for satellite litigation of a quite disproportionate kind, and the chilling effect of having to answer those kind of questions is manifest. Now, they say, well, look at legal aid, but at least that's a private process and it's a much simpler process. And secondly, they say, well, what about in the circumstance of a matrimonial ancillary relief, for example? So in effect, what they contemplate is satellite proceedings of a complexity of a matrimonial ancillary relief as part of a protective costs order process. And we say that is, of course, if in principle subjective is the right answer, well, so be it. But we say that's a very powerful indicator as to why a subjective approach, as they would have it operate, is quite inappropriate. The other things that the respondents say, and I pick these up more from their written submissions than necessarily what Mr. Eadie said, they say it's crucial here that Mrs. Palakoropoulos was not in fact prohibited, but of course that simply begs the question of subjective or objective. It doesn't answer it. And they say that the requirements of the directive would be equally achieved by a subjective test. That's in their skeleton for your Lord's hearing. We say that's not an answer. It's wrong in any event, but it's wrong in principle. So, my Lord, it's on that basis that what we invite you to do is, we say, and I hope it's clear from our written submissions and what I've said this afternoon, you need to act, we say, to ensure compliance with the requirements of the directive. We say the provisions relating to the cost assessment can and, if necessary, must be read to give effect to that position. We say the previous decisions of your Lordships don't prevent that from happening, but if necessary, they need to be revisited in the way I've described.
If necessary, what?
They need to be revisited.
Okay.
Whichever way one answers those questions, they are critically informed by an understanding of how one approaches prohibitive expense, and whether it's purely subjective, as the respondents would have it, or objective or partially subject with a subjective element.
In your paper, I'm looking at the further submissions, page 8, paragraph 21. I don't know whether you can find that. You suggest that if the matter is not clear, certain questions should be put.
We do. And obviously those questions could be rephrased, but they touch on essentially two questions, or two issues. One is prohibitive expense. That's 21.1, subjective, objective. I'll summarise it very pishly. The second is, if it arises, depending on how your Lordships analyse the procedural and jurisdictional questions, what is the nature of the obligation on a court of last instance faced with a situation which your Lordships are faced with? In effect, where does Wells take you? But we say the second of those is clear, but we recognise that the potential difficulty.
Well, it may be that point 2 really doesn't need to be addressed.
It may be that point 2
because of
doesn't need to be addressed.
the situation in which we are. It's not much good being told that we can go back to the PCO stage because we can't rewrite history.
No, exactly.
But its point is question 1 is really the main
Question 1
thrust.
is the guts of it. Yes, exactly right. Exactly right.
And the practical effect of a reference would be that your £25,000 security for costs would remain in limbo, and there would be no further costs order to be enforced against you for the moment. That's right, isn't
Simply
it?
so, yes.
Yeah.
Yes. Can I just very lastly, before I sit down, to pick up the point I left hanging a moment ago, which is the Lord Justice Sullivan's partial nod to a subjective element to a basically objective test. If you would, to first of all, Lord Justice Jackson's report, that's at tab 35 in the third bundle. You've seen this at page 1137. Over the page on 1138. 1137 is the start of the section. 1138, under the heading, the best approach for non-legally aided claimants. He cross-refers to his previous chapter 19, which you haven't got, but the crucial point is in the next paragraph. Then he says, the same shield should be given to all claimants in judicial review cases, whether legally aided or not. The legal aid cost shield was skillfully designed some 60 years ago, so that it only avails claimants of modest means. Wealthy claimants or commercial claimants will inevitably and quite rightly be exposed to the full rigour of two-way cost shifting. So, in my submission, that is the slight nod in Lord Justice Sullivan's formulation in Ghana. He says it's not purely subjective, but he's not quite prepared to go as far as say it's purely objective, because in my submission he's recognising the potential gateway or exit door, however one wants to put it, in that paragraph there.
Then courts would have to guard themselves against nominee plaintiffs being put up with large groups of supporters behind them.
Well, the large group of supporters point in my submission is not a problem, because recall the convention, it says every person, each and every person. So the fact that there may be a village or a community or whatever it may be behind the individual doesn't take one any further, because the individual is still entitled, and indeed under a duty under the Convention, to seek to vindicate the environmental access to justice question.
Well, that might make sense if each of the individuals was bringing separate proceedings, but the reality is they bring one set of proceedings and would only ever be allowed to, and they are enormously better off than an individual. Do they count as a wealthy claimant collectively?
But that's a practical concern that may need to be dealt with. We say that doesn't stand in the way of what is fundamentally a system which needs to avail the ordinary person, as Lord Justice Sullivan uses that phrase.
No, but it creates it's one of the difficulties. I'm not sure we get an answer from the European Court on it, but it's one of the difficulties.
Well, absolutely, my Lord. Just in terms of where that takes the thinking, you have below the paraphrase of Section 11 of the Access to Justice Act. My learned friend says, well, look how the statute needs to be adapted to include reference to the financial resources of the parties. I say not so, because that, which is an analogue of Section 11, as Lord Justice Jackson says it is, says that the costs judge needs to have regard to all the circumstances, including. So even without little a in that provision, there would be no difficulty. There is no need, this goes back to the jurisdiction point, there's no need to change the cost officer's jurisdiction to deal with that. And then in terms of why Sullivan number 2 departs from Lord Justice Jackson, just very briefly, you see that on page 1122. You've seen the paragraph where they depart, but you didn't see the paragraph where they explain it, because Lord Justice Jackson's formula is one that seems to be had in mind to apply at the end of the case, in other words, at the last stages. 31 on page 1122, the reasons for departing from his formula, little Roman 2, second, it relies on an exercise of discretion which we do not consider would satisfy the requirements of EU law for certainty. And that's why the second report suggests that actually Lord Justice Jackson's formula, if applied at the end of the case, certainly, which appears to be the position, wouldn't meet the wider requirements. And then we see at paragraph 35 discussion of the position of a conspicuously wealthy person, which I've mentioned already.
35?
35 on the facing page. So paragraph 35. In our discussions, the group carefully considered an additional qualification to the qualified one-way cost-shifting rule to allow cost-shifting in respect of a claimant who is conspicuously wealthy. And then they explain why they've rejected that. But we're not here in a position of framing a rule. We're simply explaining the position.
Yes.
That's why they disagree with Lord Justice Jackson. My Lord, unless I can assist further, that those are our submissions.
Thank you very much indeed, Mr. Wolfe. Mr. Eady. Sorry.
I shall be as brief as I possibly can, given the time. Firstly, in relation to the recitals to the Aarhus Convention that my learned friend placed some reliance on, my submission shortly in relation to those is that they do not assist in terms of the issue to which that reference appeared to be directed, namely as to whether or not there should be an additional burden on the taxpayer, even in cases where the claimant can well afford to meet the cost risk. And I emphasise that having a test which is focused on the individual claimant or is sensitive to the individual claimant does not, in my submission, lead to a position which is inconsistent either with the duty that is referred to, whether correctly or otherwise as a legal concept in the recitals, on members of the public to raise these issues, or perhaps more importantly, more fundamentally, with the objective of the Convention, which is to ensure effective public access to a procedure for that purpose. All it enables the court to do is to tailor its reaction to the litigation risks with that objective clearly in mind by using the tools that are available to it. Secondly, in relation to income and capital limits and matters of that kind, I meant to give in my opening submissions to you a reference into our grounds of reference or grounds of application in the materials bundle at tab 2, paragraph 21 at page A18. That is the paragraph that pulls together, as it were, the various references to the amounts of money that this particular appellant has been able to find to pay out to her lawyers. And on the second line of paragraph 21, the reference to her witness statement before this court at paragraph 2 is a reference into tab 9 at page 11, paragraph 2. And could you also, right next door to that, please, see also paragraph 4 of her statement at tab 9, paragraphs 97 to 98.
And Mr. Buxton's
Pages 97 to 98. Isn't it?
97 to 98 is her. It's a statement I think she prepared. Is a statement I think she prepared for the purpose of the application or the resistance of the application for costs at the end of the process.
Sorry, I just want to be quite sure what you mean by paragraphs 97 to 98.
No, page 97 to 98 within tab 9.
Right, yes.
Pages 97 to 98, paragraph 4.
Yeah.
Can you refer to the second?
Yes.
And if there is, there may be further material in Buxton's second statement.
Paragraph 2 and following.
Paragraphs 2 and following on that issue. And the suspicion appears to be that the only way of managing this process effectively and compatibly with European requirements based on Aarhus requirements is to have a system under which a particular individual claimant, however wealthy, can pay out jolly nearly £100,000 to her own lawyers and then turn around and say, well, frightfully sorry about that, despite the fact that I still have resources, I'm not going to pay anything, in effect, to the taxpayer. That leads into the Ireland decision. In my submission, the Ireland decision does need to be relatively carefully considered. It plainly does not go as far as to say that it is impermissible in principle to have any discretionary element in the cost system that is set up to deal with these not prohibitively expensive principles. Apart from anything else, that would be a ludicrous position, because the court must have the capacity, and discretion is the only way of ensuring that, must have the capacity to react appropriately to the justice and requirements of the individual case that are before it. The problem in the Ireland case that was identified, and it's difficult to know quite what arguments were put and how the matter was addressed, but the problem that was identified in the Ireland case is the much narrower one, which is you can't depend only just simply on an open-ended discretion at the end of the process. It was for that reason that the European Court made the reference that they did back, I think it was to paragraph 55. What is required was a system which contained the requisite degree of clarity and certainty within the codified body of law that would apply here. So all they were saying in Ireland was you can't have a system which is just simply dependent upon an open-ended discretion.
Which is rather like ours, isn't it, at the moment?
Well, my lord, that's why I rather tentatively said it's difficult to know quite how the argument was addressed, having had the great good fortune of addressing the Aarhus Committee on our behalf, entirely unsuccessfully as it appears. But in relation to the arguments that could and would be deployed, no doubt, the entirety of the system is to be taken into account. Yeah. What can't be done is to turn up and say the only thing we rely upon by way of control is the open-ended and uncodified discretion at the very end of the process. There are other elements that are involved, prior matters such as PCOs, upon which considerable reliance is obviously placed, and the fact that if anyone was under the impression in relation at least to our system that the discretion was simply open-ended, the answer to that submission would be no. The discretion is there, but it is to be exercised in accordance with the rules and in accordance with the body of case law which underpins how the discretion falls to be exercised. The general rule is, and so on, but there are exceptions if. Most of those are now found in the CPR rules that govern even that discretionary exercise at the end of the trial.
I suspect it was that wasn't clear in the Ireland case. What period in history did the facts relate to there?
The time in play, wasn't it?
How many years ago?
In the Ireland case.
Last year.
Was it last year?
Tab 2, sorry, volume 2, tab 19.
It's tab 19, isn't it? Yeah. 16th of July 2009.
Yes, that's the decision. I just wondered
And the complaint, see the Attorney General's opinion, paragraph 19 on page 131, top right-hand corner.
I mean, if you had a clear rule that the discretion must be exercised so as to give effect to the Aarhus Convention prohibition on prohibitive costs, then is the European Court really saying that that would be inappropriate?
Well, that can't be the position. That
No.
can't be the position, and in fairness, that may lead to little, if any, more clarity in terms of codification, certainty, and so on.
Yes, all this seems to go back to
2002, 2005, I think is the
it goes
latest.
back quite a few years.
Well, we don't say that much is to be read, if anything, is to be read into the Ireland decision. So far as the costs officer's jurisdiction is concerned, if I can move to the next area quickly, in relation to that and the suggestion that leasing should be used to tailor that jurisdiction, my submission is that the appropriate analytical process that should be gone through is to ask the question, first of all, how are those rules to be interpreted? What is the direction of the focus of the discretionary exercise that costs officers are engaged in as a matter of domestic law? That's stage one, and I've made my submissions about that. I say it is a process which is fundamentally focused on the reasonableness of the successful party's costs and does not permit the costs officer, in effect, to step into the shoes of the court and make sweeping reductions to an otherwise reasonable bill. Second question is whether or not leasing could, assume you find or are concerned about non-compliance with EU law, whether leasing could extend as far as to allow you to stretch that jurisdiction. My understanding of the leasing line of case law is that it imposes remarkably similar sorts of interpretive restraint and indeed flexibility to those that are found in Section 3 of the Human Rights Act. And as we know, in that context, in the context of the case law that has been developed in at my Lord's House, in particular in cases like Re S, the speech of Lord Nichols, there are essentially two forms of restraint on that exercise. One of them is linguistic. Do the words permit the stretching that is sought? But the second of them, and just as important, is a constitutional restraint. Is the court the appropriate constitutional body to be making that stretch? And my submission is that on both of those limbs, the rules that govern the exercise that the costs officer is there to do would not permit the stretch that is sought in this case, because the language and the clear purpose viewed in context of those rules is focused on the successful paying parties' costs and their reasonableness. And secondly, because, and the best illustration of this remains Section 11 of the 1999 Act, if you want to twist that focus so that it now becomes an exercise which allows them to put or to introduce percentage reduction at the end of that process focused on the position of the paying party, then we see the sort of provision that is required. You can take Section 11 or you could take either of the versions of Lord Justice Jackson or Lord Justice Sullivan in his later August 2010 report. And that is a point of some considerable importance, because the one thing that the government is, for obvious reasons, I suspect, deeply concerned about is that this case, with its history and its essentially transitional nature, if I can put it that way, should not be capable in the future of being used so as to deploy arguments in the courts below that it is entirely acceptable to just kind of ignore the PCO mechanisms that already exist and would and should require people to take these sorts of points early. And considerable caution is therefore needed in the context of this case, not to create, as it were, some general principle that costs officers can always revisit this sort of issue.
But you do accept that the court at the end of the hearing can, within the rules, make an order which would have the effect of giving effect to AHUs by, say, awarding only a percentage of the costs or capping them or something, but avowedly giving effect to the Aarhus Convention.
My Lord, I do accept that. I have accepted that in my opening, and I maintain, if that's the right way of putting it, that acceptance.
So your complaint is that that's not a matter for the cost judges, it is a matter for the court.
For the court. And the court would be entitled at that stage to take into account issues such as why PCO hadn't been applied for at the outset. That would be a relevant matter that went to the exercise of the court's discretion at that stage. But I don't take, as it were, an interpretive or a jurisdictional point at that stage. And that, no doubt, is why that point wasn't taken here. There could, in theory, I suppose, have been an objection at the July 2008 stage of this case, but there wasn't. The government, the relevant departments took the position that the argument could be had again, as it were. So I don't take that position. I draw the line at the cost officers or cost judges below engaging in the exercise which we respectfully submit is properly for the court and properly for the court at the outset in an appropriate case.
It's because it's for the court, actually, that no question of mar-leasing arises.
Right.
My Lord, yes, they can cover it. My learned friend made a series of submissions about whether or not the government's position had changed or had altered. In fairness to those who did represent the government before the Aarhus Committee, the position, I suspect, has been remarkably similar throughout. In front of that committee, the argument was run that you take into account the totality of the cost regime. What was being looked at was the compatibility with the Convention of the system as a whole, and as part of that, it was appropriate and right for the committee, and the same would apply in Europe, to take into account the totality of the system, PCOs, the ability of the court at the end of the process, and also the role performed by cost officers up here and cost judges down below, which is an important part of ensuring that there is a non-prohibitively expensive process, but is an important part and remains an important part, even if I'm right about the limit to their jurisdiction. It is still important in terms of the compatibility of the overall system that at the end of the process, when assessing the successful party's costs, that there are cost judge performing the functions that they perform, which is to look at that bill and ensure that it is both reasonable in amount and that the costs which are claimed are reasonably incurred. And it's not inconsistent to say that, but also to maintain the position that their jurisdiction is a limited one. My Lords, the only basis on which you are being ultimately, and moving to the next and perhaps final topic, the final but one, the only basis on which you are being asked to revisit all these issues, all concerned, and in particular, let us not forget the appellant who was legally advised throughout, despite the fact that all of these points could have been taken and could have been raised, particularly the subjective, objective arguments, could have been raised perfectly happily by her. We say were raised in substance, even if all the legal arguments weren't deployed quite as they were in Ghana. But the only challenge under EU law is to subjective, objective. And so far as that is concerned, I've made the series of submissions that I have. My ultimate submission is that we say respectfully that the House was right to rely in their March 2007 decision on the fact that she had not produced anything on her means of any substance beyond the most general assertions, and declined to do so, and moreover declined to do so even when the House produced the ruling that it did. But we say that the House was entirely right, and that you were permitted, the House was permitted, lawfully under EU law, to have regard to that fact. What in effect has to be said is that having regard to that fact was unlawful under EU law. Now that goes well beyond Ghana, because as my learned friend notes, whilst trying to diminish the point, even in Ghana, and even Lord Justice Sullivan was prepared, as he put it, to nod in that direction, i.e. even Lord Justice Sullivan was not saying that the test was solely objective. And once you reach that point, it really just becomes a question of, well, how wealthy? And once you accept that the question is how wealthy, you have a subjective approach. You have an approach under which it is legitimate to take into account whether or not this particular claimant should be asked to bear the cost risk, as opposed to transferring that cost risk to the taxpayer. And my submission is that there is nothing incompatible with EU law in the House having relied as one of the factors, and I emphasise as one. If you go back, for example, to the March decision, it's one amongst many factors. There is nothing unlawful under EU law in the House having relied upon the fact that they had no information, in effect, about the means of this particular claimant. No one, it appears, before you is asserting that the test is solely objective, by which I mean that it is irrelevant to focus upon the means of the individual claimant. And it's for that reason that we respectfully submit that there is no arguable incompatibility with EU law, either in the refusal of the PCO on the grounds that were given in the March order, or in making the order for costs at the end of the day on essentially similar grounds. And we do say also, and finally, that that is also relevant to the question, the domestic question, as it were, which is whether or not this House should exercise, as a matter of discretion, the jurisdiction which all concerned accept exists in principle, at least under Pinochet. Should this House exercise that discretion? And we say, we respectfully submit that the Court will need to take into account a number of questions in considering whether or not to do so. For example, was the point raised in substance or at all? Secondly, should it have been? Thirdly, was the decision in question, or the decisions in plural in question, were they arguably wrong? And I've made my submissions about that. We say plainly not, even on the view which is advanced now about Ghana. And fourthly, would it have made any difference? In other words, would it have made any difference if there had been an objective element considered at that stage, at either stage, in July 2008 or in March 2007? Would it have made a difference? Well, we know from the March 2007 decision that a range of factors was relied upon by the House in declining to award a PCO. I've made some points about public interest and how that had changed under Ghana. Go back to the March 2007 decision itself. You will see that the House specifically started by saying, we're going to assume all that. We're going to assume the public interest, the public importance, and so on. So it's a complete non-point that. The dispositive reasoning is the reasoning that features in the second half of that ruling. And we say that even if you ask that question, would it have made any difference? You are, at that stage, entitled to say, well, what would have happened if there had been some notional reasonable person, and ordinarily that should lead to the court setting the level at £10,000 or £15,000, as long as and once it is accepted that there can be a subjective element, you have to focus on the means of the individual claimant, and it is legitimate to do so. And that is all that the House did in that ruling in March 2007, that reasoning effectively being carried forward into its cost decision in July 2008. So we say this isn't an appropriate case for a reference. It is clear that the House acted properly and compatibly with EU law. My Lord's very final point, if, contrary to all of that, you are nevertheless disturbed enough to start contemplating references, may I respectfully suggest this procedural course, that the court considers its judgment, and then if it does conclude that that is a course which recommends itself to the court, that there should be an opportunity in the light of that reasoning to consider the precise nature of the question.
Certainly, and the point that was going through my mind was whether we needed to reconvene, as it were, for oral submissions, or whether you would be content to, assume we get to this point, to do it in writing. I mean, let's assume that we take this course, we would issue a judgment in which we would invite submissions on the question, and it would seem easier if we could do it in writing.
Lord, it certainly would.
Because
Can
convening us all again, given the constraints on the court's programme, is very difficult. We've had to squeeze today into a single day to achieve a hearing at reasonable time, so
Lord,
we have to watch that.
Can I suggest this course, that we all try very hard to do it in writing,
Yes.
and if it turns out that anyone is violently opposed to that, or that the court considers that there are issues which would benefit from oral submissions, then one can address that at that point.
Yes.
You're simply contemplating a reference on the precise questions, are you? I mean, if one were to come to the view, I'm not quite sure whether you were going further and suggesting that if we contemplate a reference, you should have another chance to persuade us not to make one.
No, I'm not suggesting that.
No, I think we would have to
The government is prepared to have only one bite of that particular cherry.
Right.
Yes.
Afraid it's sad to end on a tart note, but my Lord knows. Simply on the form rather than the weather.
Very well. Mr. Wolfe, do you have a point on the procedure before we finish?
My Lord, we would be content with what my Lord's contemplate, a written procedure.
Yes.
Can I just correct one slight error on Mr. Eadie's part? We do submit that the test is purely objective. The mixed, if you like to call it that, position is a fallback position. So he's wrong to say nobody is suggesting a purely objective position.
Right.
Well, my Lord, I'm very grateful for that clarification. It indicates that my learned friend is further out on this issue than the court. I was about to say even, but that would have been wholly improper, than the Court of Appeal in Ghana. My Lord, those are my submissions.
Well, we're extremely grateful to Council for their submissions, or Council, I should say, submissions both orally and in writing. We'll take time to consider our decision.